Yes, Mr. Malik.
My lords, my lady, there are two appeals before the court. I appear for both appellants with Mr. Mustafa and for Mr. Alam with Mr. West, who also appeared below. Mr. Henson, who joins us remotely, appears for the Secretary of State.
Yes. Now, before we start, could you just help us as to names? Has there been an anonymity direction in these cases or not?
No.
No. So, is there any reason why the appellants should not be known by their full names?
No.
No. Very well. Well, that means that particularly as the case is being live streamed, we don't have to worry about identifying details of those kinds.
No.
And our judgments will in due course name the appellants in the normal way. Now, I'm going to, just so Mr. Hanson has this in mind when it comes to be his turn, just check this. Are you hearing us well and clearly?
I am, my lord. Thank you very much. Can I just, on the question of anonymity, if I could just invite your attention to page 4 of the core bundle. In SA's case, in granting permission, Lord Justice Coulson said at paragraph 4, I grant permission to appeal, the anonymity restriction should not be lifted.
Thank you for drawing that to attention. Is that only in that case? There isn't a similar...
That's only in that case.
Right. Well, it's clearly a matter on which I imagine the Secretary of State doesn't have a particular view.
That's correct.
So unless Mr. Malik, in the first case, the SA case, we can find some reason for maintaining an anonymity restriction, we're not going to do so. But I obviously, in the light of that, give you the opportunity.
There is no reason. No anonymity order was made in the tribunals below. The upper tribunal's decision is already in the public domain. Right. And I do not ask the court to anonymize the name of the appellant.
Well, having come to Mr. Hanson once for that useful intervention, I'm just going to say that when the time comes for you to give your submissions, it might be possible, I think, for you to organise some lighting so that we see you better, because we see your room better than we see you at the moment because of the lighting. It doesn't matter for the moment, but we'll probably at some stage have the opportunity to illuminate you a bit better. That's going to be better, but please don't feel you've got to do it all the time. All right.
All right, thank you.
Now, Mr. Malik, the floor is yours then.
Lords, my lady, few, if any, authorities in this field can have been the subject of more judicial analysis than the judgment of the House of Lords in Chikwamba. The Supreme Court has looked at it twice. This court has sought to analyze it in some 30 different judgments. The upper tribunal and the High Court has sought to grapple with it in at least 50 reported decisions. The common issue in these two appeals, yet again I'm afraid, concerns the application of the so-called Chikwamba principle and its relation to sections 117A and B of the Nationality, Immigration and Asylum Act 2002. I shall seek to persuade my lords and my lady that the tribunals below, in both these cases, misapplied that principle and erred as to those considerations. There is an additional issue in Mr. Alam's appeal that relates to the insurmountable obstacles test in paragraph EX1 of Appendix FM to the immigration rules. I shall submit that the first-year tribunal erred as to that test, and it was not open to the upper tribunal to uphold the first-year tribunal's decision. Subject to any observations, I propose to address the court as to the common issue first, and will then make brief submissions as to the facts of these two appeals. I will then, towards the end, make some very brief submissions on the additional issue that arises in Mr. Alam's appeal. So the common issue first. Lords and Lady, I'm sure would have picked from the papers that the two appellants, who are citizens of Bangladesh, are married to British citizens who are settled in the United Kingdom. They do not qualify under the immigration rules on the grounds of their marriage because they are in the United Kingdom unlawfully. The immigration rules provide that, subject to one exception, a person who seeks leave to remain on the grounds of their marriage should not be in the United Kingdom in breach of the immigration laws. So to qualify under the immigration rules, these two appellants must leave the United Kingdom, return to Bangladesh, apply for entry clearance as spouse, and if that entry clearance is granted, then return to the United Kingdom to live with their respective spouses. Well, given that they do not at present qualify under the immigration rules, they rely on Article 8. A person's failure to qualify under the immigration rules, it is fairly well settled, is not determinative of the Article 8 claim. It is the point at which to begin, not end, consideration of Article 8. The authority for that proposition is the judgment of the Supreme Court in Hashim Ali. I will not take you to that judgment now, but for the purpose of note-taking, it's behind tab 9 of the authorities bundle, page 123, and the relevant paragraph is paragraph 41. So what in Article 8 assessment in such circumstances should entail is the key issue in these appeals. The effect of Chikwamba, as clarified in subsequent authorities, in my respectful submission, can accurately be summarized in 4 short points. First, the fact-finding tribunal must consider and determine whether the appellant, if they leave the United Kingdom and apply from abroad, will or are likely to be granted entry clearance. Second, if yes, the tribunal must take that as a weighty or at least a relevant factor in favor of the appellant in assessing the issue of proportionality. Third, in addition to that factor, the tribunal must take all other relevant factors into account, including non-compliance with the immigration rules and the public interest in having an effective system of immigration control. And fourth and finally, in considering the factors in sections 117A and B of the 2002 Act, the tribunal must have regard to the inherent flexibility within the statute. I, my lords and my lady, propose to take the court to 4 authorities in support of these propositions. First, Chikwamba itself, then 2 Supreme Court authorities where Chikwamba was considered, and finally a recent judgment of this court where those authorities were considered.
Give us the names of the 4, would you? Chikwamba.
The 2 Supreme Court authorities are Hashim Ali
Yes.
and Egyarko,
Yes.
and this court's judgment in TZ, Pakistan.
TZ.
Yes.
Yes.
It is not possible for me to take the court to every single authority where Chikwamba was considered. If my learned friend in his submission seeks to place reliance on any other authority, I will deal with that in my submission. So once I've taken you to these 4 authorities, I will then address you as to sections 117A and B of the 2002 Act. So first, Chikwamba. It's behind tab 6 of the authorities bundle.
It would be if we had tabs.
So it's page 76 of the bundle. The facts of that case are quite different from the facts of these 2 appeals. And I accept that to be the case. If you look at the judgment of Lord Scott, this is page 78 of the bundle.
We'll come to this. The leading judgment is Lord Brown, isn't it? And it's that judgment which the other members
Yes.
all agree with.
Yes.
I appreciate Lord Scott made some remarks of his own, but for the authoritative part of this text, we look to Lord Brown, don't we?
Absolutely.
Anyhow, you're starting with Lord Scott. That's fine.
Very good. So what I thought would assist if I highlight at the outset is what is said at paragraph 4, which is the point about the general public interest in having an effective system of immigration control, and the desire that those who seek to remain here permanently should apply for permission before coming to this country. So that of course was at the forefront of the court's mind. You then have paragraph 6, where you see the point that is made there, that if a person has every prospect of succeeding in an application from abroad, then what is the point in sending them back, despite the fact that there is a public interest that those who come to this country should do so with permission. As my Lord rightly pointed out, Lord Brown's judgment is the operative judgment. There are 2 paragraphs that I wish to show the court. The first is paragraph...
Just before you do, I mean, Lord Scott, at the foot of page 78, the sentence beginning, "it is or ought to be accepted." I mean, those are very significant factors, aren't they, in that analysis in paragraph 6?
Absolutely. I accept, and I have accepted at the outset that Chikwamba was a very, very different case. The spouse was a former refugee. It wasn't possible for the settled spouse to relocate to Zimbabwe. The conditions were hostile at the time. Factually, it's quite a different case.
And there's a child involved.
There was a child involved, absolutely. So it's factually a very, very different case. Just to show you two paragraphs. The first is paragraph 34. So you'll see that a wider argument was made on behalf of the appellant in that case, that an appeal can never be dismissed on the basis that a person should leave the United Kingdom and apply from abroad. Certainly accept that is the case. I'm not suggesting that an appellant must succeed in every case where grant of entry clearance is likely. You then have paragraph 44 of the judgment. And you'll see what is said in the second sentence, that only comparatively rarely and certainly in family cases involving children should an Article 8 appeal be dismissed on the basis that it would be proportionate and more appropriate for the appellant to apply for leave from abroad. So certainly in family cases involving children, the point about the child that my lord made, but comparatively rarely in other cases. I mean, for instance, if there is a case that involves a foreign criminal or a person who has a particularly aggravating immigration history, then that would be a case where it would be appropriate, though rarely, to dismiss an Article 8 appeal, despite the fact that entry clearance was likely to happen. Now, Chikwamba, as I pointed out at the outset, was then considered in a series of judgments by this court. But rather than taking you to those judgments, may I take you to Hashim Ali to show you what the Supreme Court said about it in that case. So Hashim Ali is the 9th authority in the authorities bundle, page 123.
Yes.
That was a case involving a foreign criminal, and the issue before the court as to the proper approach in assessing the issue of proportionality under Article 8. If you go to paragraph 17 of the judgment, this is page 131 of the authorities bundle, you'll see that Lord Reed made a point as to the status of the immigration rules. The point has some significance given that the requirements of the rules are not met. The rules are not the law. They are made by the minister, by the negative resolution procedure. They, to a limited extent, are subject to the democratic procedures of accountability. If you then go to page 137 of the bundle, and if you look at paragraph 32, you'll see that the relevant question was identified as of striking a fair balance between the competing interests. This is between F and G. The paragraph where Chikwamba was considered expressly is paragraph 34, page 138 of the bundle. So Lord Reed has already discussed, as it's clear from paragraph 32, the proper approach to the issue of proportionality. And then he makes the point at paragraph 34 as to the family life. And he said that the question is more complex than it might appear at first sight. And he then gave an example of a person who was residing in the United Kingdom unlawfully when a relationship was formed. But if that person leaves the United Kingdom, applies from abroad, and would be permitted to reside here lawfully, then that point should be taken into account. So this supports my first proposition, that there must be an assessment by the fact-finding tribunal as to whether an appellant would be permitted to come back. And it also supports my second proposition, that is a factor to be taken into account.
Mr. Malik, is this observation obiter in the jargon? In other words, is it an observation which was not necessary for the decision in the case?
In my respectful submission, it's not obiter. It is with respect clear that that at that part of the judgment, when one reads it in the context of paragraph 32, that Lord Reed was.
But this is a deportation case. Is there any possibility that someone who's been deported will be in a position to apply for entry clearance?
In certain circumstances, it is possible even for a foreign criminal to leave the United Kingdom and apply for entry clearance from abroad.
And be granted it?
There is of course a possibility. The rules do contemplate a person who is subject of deportation order leaving the United Kingdom, applying for entry clearance and returning to the United Kingdom following revocation of the deportation order. There is.
Well, if it's been revoked, but if the deportation order is in force, is there anything in the rules that would enable someone to apply for entry clearance to come to the United Kingdom when the deportation order is in force?
No. So what happens, milady, is that if a person with a deportation order leaves the United Kingdom, applies for entry clearance, that application is treated as a tacit application for revocation of the deportation order, and the entry clearance officer then comes up with a composite decision on whether to revoke the deportation order and grant entry clearance. And there is quite a lot of case law from this court that deals with those points. But my submission with respect, milady, is that this is not obiter. It is part of the assessment and the guidance that Lord Reed was seeking to give. But true it is that is a deportation case, but if the point is troubling my lady, the next two authorities that I will show you, those are not deportation cases.
Right.
Where the point in my respective submission was repeated and repeated with some emphasis. So you have paragraph 34 that in my respective submission supports my first two propositions. Now, may I also show you, for completeness, paragraph 41 of this judgment, page 140. This is the point that I made at the outset when I was introducing the case, that a person's failure to comply with the immigration rules is not determinative of the Article 8 claim. It is the point to begin, not end consideration of an Article 8 claim. Paragraph 41, page 140 of the bundle.
Right, and that's from Huang.
That's from Huang. It's fairly well settled.
But isn't the position, as is recognised in Agiaco, which I think you'll be taking us to in a minute,
Yes.
isn't the position rather different now? Because doesn't Lord Reed in Agiaco recognise that for the vast majority of cases, the rules do now, because there was a stage when the rules just didn't deal with Article 8.
Yes.
By the time of Agiaco, Lord Reed is recognising that for the vast majority of cases, the rules do deal with Article 8 and they do state the balance for the vast majority of cases.
Milady, even I will take you to Agiaco next, but even when Hashim Ali was considered, the rules relating to Article 8 were in place, and the issue was whether the rules were a complete code, and the clear message. I can perhaps show you paragraphs paragraph 51 to 53 of this judgment, Hashim Ali, page 143 of the bundle. Lord Reed made it clear that the rules are not a complete code.
Well, I don't think anyone's suggesting they're a complete code. My point's a rather different one, which is that by the time you get to Agiaco, the Supreme Court are recognising that for the vast majority of cases, the rules do state the correct place where the balance is struck. Well, anyway, you're
Lady-
going to take us to
yes,
Asylum in a minute.
that milady, with the greatest respect, is not how I would respectfully put it. I accept that failure to comply with the rules is a very weighty factor to be considered in an Article 8 assessment. I think milady would agree that non-compliance with the rules is not determinative, and that really is the point that I seek to emphasize.
Right. Okay.
So the next judgment is ECHR. It's the fourth authority in the authorities bundle.
Can I just make a little grumpy point about the bundle? It's much easier to make sense of the authorities if they're not in alphabetical order, but they're in chronological order, because then you can see the way the law's developed. And this is an example, because we're looking at Ali first, and it's much further along than ECHR.
Yes.
So simple-minded people, I think, find it easier.
I take the point. I apologize. I
don't worry.
take the responsibility.
You're not the only person.
The reason why I thought we would arrange it in this order is because that is the preferred way in the Supreme Court. There's a practice.
Funnily enough, I've heard that said in response to a similar question from another member of the court within the last couple of months, but we're not the Supreme Court.
So ECHR, page 34 of the bundle. So this is not a deportation case. A classic case where involving private and family life. By this time, as milady pointed out, the Secretary of State had laid before Parliament the rules concerning Article 8 in Appendix FM to the immigration rules, and the issue before the court was about the proper approach to be adopted following introduction of those rules. So may I respectfully take you to paragraph 34 of the judgment. Paragraph 49 of the judgment. I do apologize. So if you go to page 54 of the bundle, you'll see a heading, precariousness. So under that heading, Lord Reed sets out the approach to be adopted in precarious family life cases. So these are the cases where a relationship is established at a time when a person's immigration status was either unlawful or precarious. They were here unlawfully, as is the case with the two appellants. And you'll see that at the end of paragraph 49, a point is made that, well, in these sort of cases, it is likely only to be in exceptional circumstances that the removal of the non-national family member will constitute a violation of Article 8. So this is Grand Chamber in Januzzi. There is then in the subsequent paragraph some guidance as to how the fact-finding tribunal should assess the issue of proportionality. And if you look at paragraph right at the end of the concluding part of paragraph 50, which is at page 54, you'll see that where family life is established in the full knowledge that a person's status is unlawful or precarious, then weight should be attached to that in the balancing exercise. So that is the starting point. In my submission, in the next 3 paragraphs, having stated the point of principle, Lord Reed then identifies 3 matters that can reduce the public interest consideration, the consideration that you will see at paragraphs 49 and 50 of the judgment. So the first point is made at paragraph 51. It is the classic Chikwamba point. That if a person who is, the point is made that the different considerations may apply to those who are foreign criminals, the weight to be given to the public interest would be much significant than compared to a case where there is no criminal conduct. If, on the other hand, an applicant, even if residing in the UK unlawfully, was otherwise certain to be granted leave to enter, at least if an application were made from outside the UK, then there might be no public interest in his or her removal, and you'll see the reference to Chikwamba. Again, as I said, the point is not determinative. It's quite clear from the use of the word might. In different cases, different considerations would apply. If there is criminal conduct, for instance, or aggravating immigration history, or say deception, then those are the sort of cases where it would be appropriate to dismiss the Article 8 appeal, and the public interest in the removal would be much higher. But the point that I respectfully make by reference to paragraph 51 is that in the paradigm case, the Chikwamba point is relevant, and it is a point in favor of the appellant in the assessment of proportionality. It can be outweighed by other consideration, but it surely, in my submission, is a point in favor of the appellant. The second point, and this, in my respectful submission, helps would help in understanding the public interest considerations in the statute. The second point that is made is an instance where there is a prolonged delay on part of the Secretary of State. So, a second example where, despite the fact that family life was established when the appellant was in the United Kingdom unlawfully, the public interest is reduced in a case where the Secretary of State takes months and years in making a decision. And the third point is made at paragraph 53, that, well, there may well be a case where the appellant wouldn't fully appreciate that they are in the United Kingdom unlawfully. Or for instance, the spouse wouldn't know about the immigration status of the appellant when entering into a relationship. That too is a factor that is capable of reducing weight to the public interest. So the submission is that these are 3 points that are capable of reducing the weight to be given to the public interest. They are not determinative, but these are points that are relevant, must be taken in favor of the appellant in assessing proportionality.
Which of these 3 are potentially relevant in the present cases?
Only the first point is relevant in this appeal.
Yes. In both cases.
In both cases, yes.
I just before we pass away from this, because you've clearly set them out, I just wanted to not have to come back later and find out.
And
it's the first.
Was either of the 3 points relevant on the facts of Agiaco? And I'm just asking. I don't know the answer. I haven't read it carefully enough.
Well, Chikwamba in the heading is distinguished in the headnote. So,
and there was a concession in that case that no. The answer is no.
The answer is no. Okay.
Well, if Milady contemplates that the points are orbital,
I'm just interested.
My respectful submission is that, well, the points are plainly correct.
All right.
Now, finally, TZ Pakistan. This is the judgment of the senior president.
Do you mind if we just pause on the headnote at page 36? Point 3 at the top of that page was what I had in mind. Right, so it seems as if Chikwamba is being deployed as an instance of circumstances which must be taken into account. You make good your submission in principle, but in practice, in that case, it did the appellants no good. Yeah, thank you.
Now, finally, the judgment of this court in TZ Pakistan. This is the judgment by the senior president, which followed Hashim Ali and Yaqub. You have TZ Pakistan at page 320 of the authorities bundle. It is the 18th authority.
Thank you.
And the paragraph that I respectfully seek to highlight is paragraph 28, and you have that at page 326 of the bundle. You'll see you'll see that the senior president in the fourth line endorsed the proposition that I made, that what Lord Reed was seeking to do in ECHR at paragraphs 51, 53 was to identify the circumstances that will affect the weight to be given to public interest. And you will then see a reference to Chikwamba and EB Kosovo. EB Kosovo is the delay case where the House of Lords said that if there is delay on part of the Secretary of State, then that may undermine the public interest. And if you look right at the end of that paragraph, you'll see that the circumstances identified in EB Kosovo, that there is extensive delay, or the circumstances described in Chikwamba, and then those circumstances are identified where removal of an appellant who is the spouse of British national could be followed by a right of re-entry. Again, those are the matters that are capable of reducing the public interest. Those are the matters that ought to be taken into account in favor of the appellant. Again, I emphasize with respect that not suggesting that they are determinative, it can be outweighed by other considerations. So these are the four authorities that I propose to show the court. The other authorities referred by my learned friend all predate these three authorities. My learned friend will correct me if I'm wrong, and if there is any particular authority that he takes my lords and my lady to, I shall deal with that in reply. So just moving on to the statute now. Sections 117A and B. Well, these provisions were not in place when Chikwamba, Hashim Ali, and Yaqub were considered. Now, these provisions are page 2 of the bundle, the authorities bundle. If you look at section 117A, you will see that it applies where the tribunal considers a question as to Article 8, and subparagraph 2 says that the tribunal must have regard to, in all cases, to the considerations listed in section 117B. I emphasize the words have regard. So it's not that the tribunal is bound by those considerations. The duty is to have regard to those considerations. This is what I say is the flexibility within the statute. So if a tribunal proceeds on the basis that it is bound by those considerations, that would be an error of law. There is the flexibility in the statute. We then have section 117B and the relevant the material provision is subsection 4. Little weight should be given to B, a relationship formed with a qualifying partner that is established by a person at a time.
So you skip over subsection 1.
Yes, I mean that of course is the starting point. It has always been the case that maintenance of immigration control is in the public interest. That surely was the case even when Chikwamba was decided. Yep. That of course is a very weighty factor, irrespective of the statute. I
mean, before the rules came in, which you're going to take us to, there was discussion that based on the European jurisprudence, there had to be exceptional circumstances before you could override the maintenance of effective immigration controls. I mean, that's not the phraseology in the rules, but that's a starting point, isn't it?
Now, the courts, in my respective submission, have consistently rejected the idea of exceptionality. It causes confusion. The word exceptional was used.
Well, it hasn't been used in the rules. That's the point I've just made.
No. The point, my lord, was made by Lord Bingham in Rasgar in 2004. He used the word exceptionality, and that caused confusion. And then he clarified in Huang that there is no test of exceptionality, and Huang has then been consistently upheld. And my lord is absolutely right that exceptionality is not the test that the rules use. It is not the test that applies in assessing Article 8.
But Huang was decided at a stage when there wasn't anything about Article 8 in the rules.
No, but yes, that is correct. But within Huang, Lord Bingham said that failure to comply with the rules was a relevant consideration. There was a desirability in having a system of immigration control by the rules. Even when Huang was decided, there were rules as to leave to remain on the grounds of their marriage. So was the case in Chikwamba.
But is the position we're in, I was looking at paragraph 60 of Agyarko. I mean, that's the correct approach, isn't it? Do you say that it's page 57? Is Lord Reed, have we moved away or have we moved anywhere different from paragraph 60 of Agyarko?
Yeah, that is the correct approach. That is the correct approach. And see paragraph 58 as well about the words exceptional circumstances and how those words created confusion. But the correct approach is set out at paragraph 60. Failure to meet the rules is a relevant factor. But the ultimate question is striking the right balance, conducting a balancing sort of balance sheet approach.
So when was Part 5A brought in?
It was
Immigration Act 2014.
2014, yes.
The 28th of July 2014.
Thank you very much.
So the little weight provision is in subsection 4 of section 117B, page 3 of the bundle. And you'll see that there is a separate little weight provision for private life at subsection 5. Now that, I say with respect, is a matter that the tribunal must have regard to. But if the 3 points identified by Lord Reed in Agyarko are in play, then the tribunal must apply the flexibility So where, for instance, the relationship was established when a person was residing here unlawfully without appreciating that his residence was unlawful, flexibility applies. Where the Secretary of State retains an application for months and months and years, flexibility ought to be applied. And likewise, in my submission, where it is certain or likely on balance that entry clearance would be granted from abroad, then that too is an instance where flexibility ought to be applied. So the tribunal, in my submission, is not bound to attach little weight in those circumstances. Whether or not it should do so depends on the facts, but there ought to be a recognition that it's not binding.
I understand what you mean by flexibility, but I think we might have to be clear that we're not talking about applying flexibility to the individual components in the menu of possible situations, but surely the position is that there has to be a case-specific balancing exercise carried out which takes into account all of the factors that turn out to be relevant in the case in hand, and that weight is going to be allocated appropriately to each of those factors. And the flexibility is inherent in the process, but it's not really a question, is it, of not reading the factors for what they are.
I accept that, and may I show you how?
I mean, isn't the point that it isn't an that Section 117 capital B is not an exhaustive statement of the relevant factors?
Yeah.
So there are potentially relevant factors that aren't referred to in Section 117.
Yes.
B.
Yes, I have no difficulty, lady, with that observation, and indeed with the observation that my Lord has made.
Also, in this list, point 6 is also stands out in a sense that there's a saving provision in relation to cases where there's a child, where it wouldn't be reasonable to leave the UK.
Yes. The point, and I will now show you how Lord Wilson dealt with the flexibility in the case of Ohio. But the submission that I'm seeking to advance is that if a tribunal proceeds on the basis that it is bound by the statute to attach little weight to a family life established at a time when a person's status is precarious or unlawful, that with respect would be an error of law.
Well, but why? Because Parliament has said tribunals have got to have regard to these factors.
So the submission, milady, is that in one particular case, on its own facts, the tribunal can have regard to this consideration, but yet conclude that it wouldn't be appropriate to attach little weight to the family life.
I'm not sure I understand that. There might, I can understand a submission that said there might be other factors in the case which meant that although little weight was given to the things that little weight is required to be given to, for something else that would tip the balance further in the direction of the person who was applying for leave. But at the moment, I'm not really understanding how if you're required to have regard to a stipulation that little weight should be given to a factor, you can somehow ignore that.
Well, have regard to, in my respectful submission, does not mean must comply with.
I think, could you put your point this way? If you go to paragraph 52 of Agyarko, the point is that in section 117b you have a balancing exercise, and on the one hand you have the public interest in the maintenance of effective immigration controls, and on the other hand you seem to have, on the opposite side of the scales, two factors which relate to a private life. That's subparagraphs 4 and 5. And in 52, Lord Reid does say it's necessary to bear in mind that the cogency of the public interest in the removal of a person living in the UK unlawfully is liable to diminish. And then he goes on, or looking at the matter from the opposite perspective, the weight to be given to precarious family life is liable to increase if there's a protracted delay in the enforcement of immigration control. And he seems to be envisaging there that in certain circumstances, rather than giving little weight to the factors in subparagraphs 4 and 5, the weight to be given to a precarious family life may increase. So you're saying that's an indication that there's some flexibility in the weight to be given to those factors. Is that the way?
Well, my lord, I will, with respect, adopt that.
Well, I mean, don't adopt it just because I said it.
Hold on a minute. Hold on a minute. Agyarko was decided before
Yes.
Part 5A came into force.
Absolutely.
So
I'm sorry, I'm not understanding that. I'm missing something here. You've just told us that 5A came into force in July 2014.
Yes, but
yes,
they
but
were...
the facts in Agyarko happened before.
They were
Right, so although the decision in Agyarko relates to a previous statutory environment.
Yeah.
Yes, the 2014 Act had transitional provisions attached to it, so the operative decision was taken before the...
Right, okay, thank you.
So the point that you can make, perhaps, but bearing in mind the statement in paragraph 52, is perhaps not that you can give more than little weight to precarious family life. What you can do, however, is say, well, there are other factors in the case that mean that the weight to be given to the public interest is diminished. So it's the first half of Lord Reid's statement.
Lady, I do with respect make that point, but I do also submit, my lady, and I submit this with respect. Of course, is that it is possible for a tribunal to attach more than little weight, even in the circumstances where family life was established at a time when the appellant was residing in the United Kingdom unlawfully. If one reads the statute, milady, in the way that milady contemplates, then in my respectful submission that wouldn't be consistent with the words have regard to.
But it's must have regard to. So the tribunal's got to have regard to a series of stipulations.
Yes, and having regard to those stipulations, it is, in my respectful submission, possible for a tribunal, in an appropriate case, to attach more than little weight to either private or family life. Now, may I?
You mean that if read literally, for example, focusing on subparagraph 4 of 117B, which is particular focus in our case.
Yes.
If one was to read that just baldly, as a statement that a precariously formed relationship was never going to get more than little weight, you say that would be going too far.
Yes, and I'll show you Rupiah now just to make that submission good, because that may then end up in violation of Article 8, and the entire purpose of this statute is to ensure that the ultimate outcome is in accordance with Article 8. And as Lord Reid identified in Agyarko, the Strasbourg does not say that little weight should always be given to such family life. There are the 3 exceptions that Lord Reid identified.
But to pick up my lady's point, in sort of contradistinction to the point I put to you, if Parliament had intended to allow the more flexible weighting of a precarious family life, as Lord Reid indicated in paragraph 52 he might have done, wouldn't they have used different wording? I mean, then in paragraphs 4 and subparagraphs 4 and 5, subsections 4 and 5. I mean, it's quite definitive. Little weight should be given to. It doesn't suggest, presumptive. Starting point is little weight, but it might get more. I mean, it's quite definitive? Is there any sort of indication that Parliament actually was unhappy with what Lord Reid had said in paragraph 52? Because they hadn't seen it, presumably, so that they...
I accept that it's quite definitive, and that essentially was the reason why Lord Wilson, in my respectful submission, struggled to identify a flexibility, so to ensure that the ultimate outcome after the application of the statute is compatible with Article 8. And his answer was that although there isn't any flexibility in Section 117B, there is ample flexibility in Section 117A. So subsection 2, my lord, does not say that in considering the public interest question, the court or tribunal must apply considerations listed in Section 117B. It says that the obligation is to have regard to those considerations.
Yeah, so you've got to show us where we get to on that.
Yes. And perhaps just to answer the point that is troubling a lot, it may be of some assistance to compare the language used in subsections 4 and 5 with subsection 6. You will see that subsection 6 is more determinative, in the sense that it says positively that the public interest does not require the person's removal, and then there is an exception about the child. Parliament, for instance, could have said, it did not say for a good reason, that the public interest would require a person's removal where family life is established. At
one can test it like this, can't one? If you're looking at say sub 5, little weight to be given to private life established at a time when the status was precarious, then let's suppose the person had been there for 20 years.
Yes.
And there was a massive delay in making a decision.
Yes.
Then it could not possibly be said that the fact that 20 years ago they had established private life precariously was something that the court, the tribunal, was bound to attach only little weight to. A factor of delay, as has been said, might mean that the relationship had become extremely important and weighty.
Yes. Yes, and to attach little weight to the relationship in those circumstances, my submission would not be consistent with Strasbourg jurisprudence dealt with in ECHR. And the ultimate submission is that Parliament would not have intended for an outcome where after application of this statute, in one case, one comes at a conclusion that is actually incompatible with Article 8 itself.
But isn't the point then that the long delay is a factor that simply isn't referred to in 117B, and 117B doesn't purport to be an exhaustive list of relevant factors? So the flexibility inherent in 117B is that there's a range of factors not specified which can be taken into account where appropriate.
Yes, so on that, on Milady's observation, the tribunal will attach little weight to the family life, but still allow the appeal for the reasons having regard to the delay.
Yes,
and other
because they'll say, well, okay, little weight to this precarious family life, but equally little weight to immigration control because the Secretary of State sat on her hands for 20 years.
Lady, I said with respect, I do respectfully make that submission, but I do also make the submission that I've made, that it is possible in my respectful submission, without doing violence to the words of the statute, for a tribunal to attach more than little weight if it considers appropriate on the facts of the given case. So Rupia is the judgment that deals with this flexibility. It is the 15th authority in the bundle, It starts at page 288. So this is a private life case. The appellant had lived in the United Kingdom for many, many years. She arrived here in 1997 and then established a private life at a time when her immigration status was precarious. And the issue before the Supreme Court was about proper construction of Section 117B.
So she had leave between 1997 and 2010.
Yes, but it made no difference, because the Supreme Court said that if a person has limited leave to remain, then that person's status is precarious. So anything short of indefinite leave to remain is precarious immigration status.
Okay, so it's precarious but not unlawful.
Yeah. If you go to paragraph 49 of the judgment, the judgment deals with a number of issues arising as to Section 117A and B of the 2002 Act. Not all those issues are relevant, but paragraph 49 is the paragraph where Lord Wilson deals with Section 117A 2A, the provision that I've placed my emphasis on. And you'll see that he has said that the Parliament's instruction is to have regard to the little weight provision. He then makes the point that the drafting would not win any prizes, but and lady, Section 117B cannot put the decision makers in a straitjacket, which constrains them to determine claims under Article 8 inconsistently with the Article 8 itself. Inbuilt into the concept of little weight is a small degree of flexibility. This is, in my respective submission, a support to the submission that I made. And he then refers back to paragraph 36.
Is he saying that's because there's no definition of what little weight is? So little weight might be, 10 grams or 50 grams. Is that the point he's making? He talks about a small degree of flexibility.
Yes, so you'll see a reference to paragraph 36 above, just between B and C.
Right.
And paragraph 36, I'm not sure if it answers the question, but given that there's a reference to that, it's at page 299. You'll see that the point that was made there, that the intention of this provision is to ensure that the final result is compatible with Article 8. And then he said that, well, if that is the intention, then one has to find some flexibility somewhere in the statute. And that is then dealt with at paragraph 49. So my submission with respect is that there is ample flexibility within Section 117A 2A, given that the obligation is to have regard to the little weight provision. It is possible in one case for the tribunal to attach more than little weight to a private life, and I do also submit that if I'm not correct, then as my lady pointed out, it's not an exhaustive list, and other considerations can also apply that would undermine the public interest in having a system of immigration control.
Right. So.
But, and you'll see what is quoted in paragraph 50 against letter D, that it is possible, without doing violence to language, for such generalized normative guidance to be overridden in exceptional cases. That is the little weight guidance.
So is this the only passage in Lord Wilson's judgment in which he addresses this point?
Paragraphs 36 and 49. Yes.
Right. So what in the end? What in the end did they decide on the facts?
Well, he concluded that the tribunal in that case erred. This is paragraph 58. So, section 115B required him, the judge, to give little weight to her private life, but that requirement was subject to section 117A2A, which conferred on him to have limited degree of flexibility. And Lord Wilson said that because that flexibility was not recognized, he would allow the appeal. But by the time the matter reached,
She got leave under
Supreme
another
Court, she
route.
got leave. But the point is that failure to recognize the flexibility was an error of law. Lord Wilson said that he would
Well, it's a
allow it.
limited degree of flexibility, isn't it? That's the quality of the flexibility that's being spoken of here.
Absolutely, and it applies. The limited degree of flexibility applies, in my respectful submission, in the three instances that Lord Reed identified in Yaku at paragraphs 1 to paragraph 51.
Well, I take from this that one doesn't simply read the bold words of the of 117B in isolation, but that one has to have regard to the fact that they're there in order to make sure that the outcome is convention compliant.
Yes.
And that in order to achieve that, there will be a limited degree of flexibility where there are strong countervailing considerations in the individual case.
Yes. The submission that I will make when I'll take you to the facts is that the tribunals below made the same error as the tribunal made in Rupiah in failing to recognize the flexibility.
Right.
Now the final authority that I will address the court on is the upper tribunal's decision in Eunice. So this is the decision of the presidential panel where Chikwamba was recently considered. It is the 20th authority in the bundle, the last authority, page 364.
346.
I do apologize, 346. I'm grateful to my letter friend. The judgment deals with a number of different issues. The conclusion as to the Chikwamba point is in head note 1.
Yes.
The way the case was argued before the tribunal was that if entry clearance is likely to be granted, then there can never be a public interest in the removal. That's not how I put my case.
Could you just tell us before you go into this, is Eunice something that you're relying on, or is it a target of your submission?
No, it is. The Malone Front seeks to rely on it, and I'm seeking to submit that it was wrongly decided.
Right. And could you just, in a sentence, as it were, or however many sentences you need, just tell us it was wrongly decided because?
For one simple reason, which is that the tribunal did not appreciate and apply the flexibility in section 117A 2A of the 2002 Act as
Mandated by Rupiah.
Now, there is no, I do not propose to take the court to the actual analysis, but it is immediately clear that there was simply no consideration of Rupiah at all. There is only one reference to Rupiah, but that relates to an entirely different point. Page 365 of the bundle, and you'll see a reference to Rupiah at paragraphs 102B. So Rupiah, in addition to this flexibility, said that a person's inability to speak English and financial independence were neutral factors. So prior to that, there was a view that if a person is able to speak English, if he's financially independent, then that positively counts in the appellant's favor. But that is the only reference to Rupiah. no recognition of the flexibility. That the judicial head note, which is the ultimate conclusion, does not reflect that flexibility within the statute, and that is my sole complaint against as to this decision.
Do we know whether the point that you're now relying on was argued in the upper tribunal?
No, it seems that it wasn't. And as I said, it appears from the decision that the way the case was put to the tribunal was that if entry clearance is likely to be granted, then there can never be public interest. Do not make that point.
But seeing as the takeaway messages in the head note from a decision of this kind, what I appreciate you say it doesn't go into repair, and that's no doubt does reflect that it wasn't argued, because it surely in a thorough decision of this sort would have gone into it had it been argued. Yeah. But what's wrong with one? I mean, it doesn't, you say, refer to flexibility, but it just says you can't short circuit 5A by going straight to Chikwamba. That's hardly objectionable.
Yes, I mean, read it in that way. I have no difficulty with that, but the way it was being read in my respectful submission by the tribunals below,
right,
was that Chikwamba no longer assists anyone following the introduction of sections 117A.
All right. Well, you'll make good that when you come to consider this.
But it read it in that way. I have no difficulty with that. My sole issue with this is that there wasn't a recognition of the flexibility. So these are my submissions on the law. If I may now make some brief submissions on the facts of the two appeals, and once I've made those submissions, I will make some brief submissions, as I said, on the additional issue that arises in Mr. Alam's appeal. Now, the first year tribunal's decision in Mr. Alam's appeal is at page 152 of the court bundle. And given Lord's Milady, I propose to deal with the additional issues separately. I may have to come back to this decision to deal with the insurmountable obstacles test. But my submission is that the tribunal made two errors of law. The first error is at paragraph 27. This is page 158 of the bundle. After referring to section 117B at paragraph 26, the judge said that I'm required by the immigration rules. That seems to be a typo. I think the judge meant I'm required by the statute to place little weight on a relationship formed with a qualifying partner at a time when the appellant was in the United Kingdom unlawfully. So the first error in my submission is failure to recognize the inherent flexibility within the statute. The same error that in my respectful submission Judge Blundell made in Rupaya. So this judge proceeds on the basis that Parliament has directed this judge to attach little weight. But
I mean, it's equally consistent with the correct self-direction, because as I understand all Wilson's reasoning, what he's saying is that little weight is intrinsically a flexible concept, because there's the concept little weight, and there's very little weight, medium little weight, and larger little weight. That's how I read what he's saying. So if you're reciting the statutory language, why does one assume that there's a misdirection?
Well, the judge has referred to section 117B at paragraph 96. There isn't a reference to section 117A 2A, and
well,
I take Milady's point, but my submission is that if one looks at the analysis that immediately follows paragraph 27,
right,
it is, in my respective submission, apparent that the judge felt that the judge was obliged to place little weight to the relationship, irrespective of other considerations.
Well, I know you'd accept that the thing has to be read as a unified piece of reasoning, and one sees that going on to the next page in paragraphs 31, 32, and so forth, the judge is then dealing with balancing exercise considerations.
Well, that is this, yeah.
I mean, now, would it not be fair to her to say that she was, as it were, having cited the statutory language, she was then going to go on to perform the sort of exercise that she was rightly required to perform?
Yes, and that takes me to my second point.
Well, I wondered
which was directly to paragraphs 32 and 33. Right. Now, there is, of course, as my Lord rightly pointed out, a balancing exercise. But what is missing from those paragraphs is a clear finding as to whether the appellant will be granted entry clearance from abroad, and a failure to recognize that that is a point in the appellant's favor in the balancing exercise. If you look at paragraph 32, the judge refers to Chikwamba and then refers to Egyaku and highlights the passage that you have seen, that if it is certain that a person would be granted leave to remain, then there might be no public interest in their removal. But if you then look at the next paragraph, you'll see that that isn't a point that is taken in the appellant's favor. So when I, my lords, my lady, will recall, when I summarized my four propositions, I said that the tribunals must consider and determine whether a person will get entry clearance if an application is made from abroad, and if yes, to take that as a weighty factor in assessing the question of proportionality. That factor, which was obviously present here, because I do say that it is certain that this appellant, if he leaves the United Kingdom, applies from abroad, will certainly get entry clearance because he meets all other requirements of the rules. There's no recognition of that. No weight is given to that factor in favor of the appellant. What the judge says, in my submission, is quite the opposite. If you look at the way the judge concludes that paragraph, the judge says that, well, if he wishes, the appellant wishes to make a family life in the UK, he can do so by making the same applications as others in his position, i.e. to leave the country to make an application from abroad. So my submission is that the judge read the Chikwamba point as a point against the appellant, but on correct analysis, it was a point that was in the appellant's favor.
Could we go back? I'm sorry to be deliberate about this, but could we just go back to your first point, because I'm wondering whether it's really a point of any substance. This was paragraph 27, the place little weight. I mean, if you go then to 33 in the second sentence, she then takes into account the subsisting relationship.
Yes.
So I mean, is 27 really more than a forensic language point? Is your real point here not an error of law by having identified the Chikwamba point, but then not gone ahead and put it in the scales? Is that not really your complaint?
Absolutely, my lord. The reason why I felt it appropriate to make the first point was because reading paragraphs 32 and 33, the reason why the judge did not attach weight to that particular point in the appellant's favor was because the judge took the view that the statute requires the judge to attach little weight.
I do understand that, but it's always nice to be able to consider if there's one error of law rather than two.
I see.
It just seems to me that your point about paragraph 27 is, as it were, clearing the way for your actual point.
Lord, I've
So you would say, I imagine, that the fact that the judge did not specifically give credit for the Chikwamba element is probably because of what she said in paragraph 27.
that is the point. So this is a case.
But it's really a single. I mean, it's really a single point here rather than two, isn't it?
It is. I wouldn't disagree. So this is a case where the judge could have attached more than little weight to the family life. The judge did not do so, in my submission, because she misread the statutory provision, and that really is in my submission is the error of law.
If one reads paragraph 33, isn't she really saying, yes, he could go and make an application for entry clearance, and he jolly well should go and make an application for entry clearance because he should do the same thing as others in his position are expected to do. So she's taking the Chitwang point into account and saying, on the facts of this case, it doesn't help him.
What the judge in my submission is doing is that the judge is making the point that it is possible for this person to leave the country, to apply for entry clearance, to come back, is a factor against him. That, well, he shouldn't be treated differently from those who comply with the law, and that's the point against him.
No, that can't be right. What you're really complaining about, surely, is that she didn't weigh in the balance that if he went, he'd be back.
That is a point in the appellant's favour.
Yes, but nobody can deny that it's a point in the public interest favour that people who won't comply with the rules, that's a detriment to the public interest.
Accept that, yes.
Right. So it's not a complaint really about what she's said on that point. It's what your complaint's about, what you say hasn't said.
That is the complaint really. Now, if my lords and my lady are persuaded with this submission, my lords and my lady will take the view that it wasn't open to the upper tribunal to uphold this decision. If the decision is wrong in law, it's wrong in law. If my lords and lady.
All right. Well, are we going to see what they said about it?
So the upper tribunal's decision is at page 98 of the bundle. The upper tribunal deals with a number of different authorities and relies heavily on Eunice. The actual conclusion is at paragraphs 53 to 56. The judge accepted that there was a clear finding that the other requirements were met, but the Secretary of State accepts that all other requirements are met. Now, the real point is made at paragraph 54, and the point is that the judge did take the Chikwamba factor as relevant to the overall proportionality balance. And the judge then says that, well, given that that is the relevant factor that the judge looked at, there is no error of law. But my submission is that the judge refers to Chikwamba, but did not appreciate that the point that the appellant can leave and come back is a point in the appellant's favor. It reduces the public interest. It is capable of attaching more than little weight to the family life.
Right, so your target here might be paragraph 56.
Yes. and the submission, of course, paragraph 56 says that there wasn't any need for the judge to make a finding as to whether the appellant would qualify, but that, with respect, is irreconcilable with Hashim Ali and Egyako. How is it possible for a judge to have regard to the Chikwamba point without actually making a finding as to whether the appellant can come back? But Malignant Friend accepts that on the facts of this case, on balance, if the appellant leaves the United Kingdom, he'll be able to come back. His application will succeed on balance. Paragraph 56, two points that with respect I make at paragraph 56. The first being that the upper tribunal was wrong to say that that it was okay for the tribunal not to make a finding as to whether the requirements of entry clearance are met. And secondly, this does not answer the point that I've made, that the so-called Chikwamba point was actually a point in the appellant's favor in conducting the balancing exercise. These are my submissions on Mr. Alam's case. Mr. Rahman's remade decision by the upper tribunal is at page 115. Now, I do not propose to take you to the first-year tribunal's decision because that decision was set aside as being wrong in law. Page 115 of the bundle is the upper tribunal's decision. And I make the same 2 points that I make. The first is that there is no clear finding by the upper tribunal as to whether or not the appellant will be able to come back to the United Kingdom if he leaves the country and makes an application from abroad. The tribunal should have considered and made findings as to that. And the second point is that if one looks at paragraph 85 of the judge's decision, page 135, the judge misapplied the Chikwamba principle. The judge says that, well, if there are no insurmountable obstacles to relocation, then, well, Chikwamba wouldn't help. But that surely is not what Chikwamba says. If one reads Chikwamba in that way, it could never apply in a case where the requirements of the rules are not met, because the rules, one of the requirements in the rules is to demonstrate that there are insurmountable obstacles to relocation. So that cannot be determinative of the Chikwamba point.
Well, but the point might be that the rules now are different. So what was being considered in Chikwamba was an asylum policy instruction. There wasn't anything in the rules about insurmountable obstacles. And the position now is completely different because the court's not considering an asylum policy instruction. It's considering, first of all, the immigration rules, and secondly, the framework in Part 5A of the 2002 Act, which set out a different decision-making process.
Yes.
So I'm not sure it's not clear to me immediately that is necessarily a persuasive submission.
Lady, if the upper tribunal was making that point,
Yeah.
It would have been justified if Chikwamba was the only authority. But Chikwamba has since been considered in the authorities that I've taken you to. And what is, in my respect, submission clear is that it's not, the application is not limited to a case involving an asylum applicant. So the broader point is that if a person is able to return to the United Kingdom after applying entry clearance, then that is a factor that is to be taken into account in that person's favor in proportionality balance. And that is not what the upper tribunal, in my respect of submission, recognized. What the upper tribunal said essentially was that, well, because there aren't any insurmountable obstacles, well, that's the end of the matter, and Chikwamba can never assist. Well, that in my submission cannot be right. If I may, perhaps also just highlight what the judge said at paragraph 87. The judge there said that, well, I'm considering section 117B, and then with respect makes the same error that was made in Rupiah. Again, of course, I appreciate the point that lady made when I was making my submissions earlier. The judge said that I'm able to give only little weight to the appellant and sponsors family life, and then says that, well, little weight does not mean no weight. But the judge took the view that the obligation is to attach little weight, no recognition of flexibility. It's the same point that I made in relation to the other case. So for these reasons, I submit that the tribunals in both these cases misapplied the Chikwamba principle, failed to recognize the flexibility within section 117A, and erred in failing to recognize that the ability to come back to the United Kingdom by obtaining a fresh entry clearance is a matter that counts in the appellant's favor, both in reducing the public interest and can also lead to attaching more than little weight to the family life. Unless Lord Milady, you have any questions, I'll now move on to the additional point that rises in Mr. Allen's appeal. Very good. So that concerns the insurmountable obstacles test. Now, before I take you to the decision, can I show you one authority that assists the court as to what insurmountable obstacles test actually entails, and that is the judgment of this court in the case of Lal. That is the 13th authority, page 254 of the bundle. So the appellant, who was a citizen of India, was facing removal despite the fact that she was married to a British national. She argued that there were insurmountable obstacles to relocation because he, the spouse, was sensitive to heat. The tribunals dismissed the appeal, and the matter then reached this court. If I may take you to paragraph 9 of the judgment. So you'll see the relevant rules. I'm not supposed to take you to the rules. You have the rules elsewhere in the bundle, but the relevant rules are at paragraph 9. So in order to qualify, one has to demonstrate that the applicant has a genuine and subsisting relationship with a partner. There's no issue about it. And there are insurmountable obstacles to family life with that partner continuing outside the UK. And then paragraph EX2 explains what insurmountable obstacles mean. Where that paragraphs 36 and 37 are the paragraphs where the court deals with the proper construction of this phrase, and identifies the approach that one has to take. So paragraph 36. So it's a two-stage approach, and that is the approach that I would submit was not applied by the tribunal in this case. So the tribunal must first decide whether the obstacle amounts to a very significant difficulty, and if that threshold is met, the next question is whether that difficulty is one which would make it impossible to relocate, or taking any particular steps one can address that difficulty. It's a 2 or a 3 stage test that one applies. Paragraph 37 makes the point that it is a test that should be applied in a practical and realistic sense. Must be practical. I mean, of course, one cannot apply it literally, because as once Lord Justice Laws said, that there's no obstacle that is insurmountable. Ultimately, every obstacle is surmountable, but one has to apply it in a practical and realistic way. Now, if I may now take you back to the decision made in Mr. Alam's appeal and make some very brief submissions on it. So it's page 152 of the core bundle. Now, if you look at paragraph 10 of the decision, this is the appellant's claim. So the wife is a British national who was born and raised in the UK, a difficult childhood, no connection with Bangladesh, and does not wish to relocate. She was in employment as a social worker, and that is how the case was put. Now, if I may then show you, you'll see a heading just above paragraph 154, oral evidence. And if you look at paragraph 15, so the wife gave evidence. There is a typo in the second line of paragraph 15. She said that she has never been to UK. It must be Bangladesh.
Yep.
She has always lived in the UK. She works. She was in touch with foster parents. She was taken into care when she was a child, had a very difficult childhood. She sees them once in a month. They're very sportive. They are in touch. She has birth family in the UK, but she does not speak to them. She only has contact with the husband's family. Paragraph 16, well, she wasn't aware that the appellant was living here unlawfully when they met, but became aware of that thereafter. Paragraph 18 is the paragraph where you will see a submission that the appellant spent 6 years in the care system. So just moving on to the findings. Now, if you go to paragraph 21 of the judgment and see 1, 2, 3, fourth line, say this with the greatest of respect and diffidence, that this is a classic stereotype approach. The judge says that on the face of it, she, the person who was born in the UK, lived here all her life, has chosen to marry someone who is from Bangladesh, who has not had the same upbringing, but she appears to have immersed herself into his culture. She has already culturally adopted to the appellant's culture and language. It's completely, with respect, unjustified. There was no evidence, I say, before the judge to justify that conclusion.
What age was, probably should know this, what age was the appellant's wife when she was taken into care?
Sorry, she?
Yes, what age was she when she was taken into care?
She was 13 years old.
Right, because it does, there is a finding in paragraph 19 that her birth parents originated from Bangladesh. Is that right? So did she, I mean,
yes.
My point is, did she live with her birth parents until she was 13?
The birth parents were from Bangladesh,
Right.
but I'm not sure if there was any evidence before the judge to to make the point that the judge made at paragraph 21. But even if, I mean, she was of Bangladeshi, she is of Bangladeshi heritage with parents born in Bangladesh. What is the basis for the judge to say that she has immersed herself into the husband's culture and adopted the husband's culture altogether?
Well, was it a ground of appeal that the FTT had made a finding for which there was no evidence?
I mean, of course, you mean grounds of appeal to the upper tribunal?
Yeah.
Yes, and I will.
The grounds of appeal appear at page 99.
Yes.
Two grounds to start with, and then a third one.
So ground one is the classic Chikwamba point.
It's not obvious that any of these, I mean, the first and the third don't touch on My Lady's point, and
yes.
second,
Lady,
second is a reasons.
yes.
Right.
There is ground 2, page 253 of the bundle, that concerns insurmountable obstacles.
Did you say 253?
Yes, page 253.
Thank you.
You'll see that a range of complaints were made. Lady,
But not this one.
if I just can I just make my points and then show you the grounds as to where.
Sure.
The reason is that, well, all these points were part of my grounds of appeal that I drafted to this court. They're part of the original skeleton argument. Permission has been granted on these grounds.
Yes.
Milan friend is not taking a pleadings point. He's not saying that, well, this court should dismiss the appeal because these points were not properly made before the upper tribunal. Milan friend says that these are not good points, and that is how.
I think I might take this point though.
Because this is a rather self-contained point.
Yes.
The point you're making at the moment, Mr. Malik, is that there was no evidence to support this finding by the first-tier tribunal. What I'm simply trying to establish is whether that was ever a complaint that was made to the upper tribunal. It's not obviously what's part of your grounds of appeal to this court either.
Sorry. They were certainly part of the grounds of appeal to this court. I mean, I made the points in the grounds and the skeleton, and permission was granted specifically on this.
I'm just going to remind myself of this particular part of your skeleton argument, which is paragraph 34 on page 20.
Yes, you see that I've made sort of 6 points. These were the points on which permission was granted in all these points.
Yes. All right. Well, I mean, I think we've now grasped that.
Yes.
That particular point.
Yes. So that is the first point. Secondly, so you have taken a note of what the judge said at paragraph 21. But then the second point is, with respect, is that what is said at paragraph 21 is irreconcilable what the judge said at paragraph 19. Now, if you look at the end of paragraph 19, 1, fifth last line of paragraph 19, on the face of it, they are very different, the appellant and his wife. This is page 156, milady, of the bundle.
Yeah.
Fifth last line of paragraph. They are very different. She does not even speak the language as fluently as he does. And she has been brought up in a white English foster home during her teenage years, although she is from Bangladeshi family. So the two findings with respect are simply irreconcilable. The judge cannot say at paragraph 19 that they are very different. She does not speak English, resided with a white foster English family, does not know about the language, and then at paragraph 21 say that, well, she has immersed herself into Bengali culture. So the two findings in my respectful submission do not add up. Thirdly, milady, if you look at milady and my lords, if you look at paragraph 21 again, so you have taken a note of the part that I have targeted in my earlier submissions. If you look at eighth line of paragraph 21, the judge says, I do not accept that living in Bangladesh would be unduly harsh for her based on the information that I have. That's the wrong test. Now the statute, section 117C, says that that is the test that applies to foreign criminals. So if a foreign criminal is married to a British national, then they have to demonstrate that relocation would be unduly harsh.
Assuming that you're right about that, and that the judge should have addressed the test of insurmountable obstacles, is this any more than a semantic point?
It is, with respect, because you'll see that there is only one sentence that, well, on the basis of the information, that the relocation isn't unduly harsh. But there isn't in my respectful submission a clear finding that there aren't insurmountable obstacles to relocation. At least one cannot be confident that the judge had applied the correct test.
Right.
Then, milady and my lords, if you just go back to paragraph 19, it's a lengthy paragraph, but if you look at page 156, you'll see line 10 at page 156. So the judge acknowledged that the appellant at the time was vulnerable when she was a child and was taken into care, and then says, well, she probably still vulnerable. Now, vulnerability is a matter that can present a significant obstacle to integration. That is why I showed the judgment of this court in Lal to my lords and my ladies. So the judge simply failed to engage with that at paragraph 21 when the judge said that relocation would be unduly harsh. The judge should have considered whether the vulnerability was a factor that was capable, that could amount to very significant difficulty, and secondly, whether any steps could have been taken by the couple to address that difficulty. There isn't an application of the three-stage or the two-stage approach that was mandated by this court in Lal. And the final point that I make concerns the seventh last line of paragraph 19. Now this is where the judge says that she married at the age of 16 to a man who did not initially tell her that he was in the UK unlawfully and who was 11 years older than her. And the judge says that, well, that causes me some concern. The judge has not explained in my respectful submission, what that concern was.
Well, it's obvious.
Well,
You, you marry somebody who's just turned 16, who's in care, and you don't tell them that you've no right to be in the country.
yes. So,
Right. Well, I wouldn't press that one this time.
yeah. No, the point that I was seeking to make was that may well be a concern that goes to the relationship itself, as to whether the relationship is genuine, subsisting, committed, or whether the appellant was seeking to use the...
Yes, well, the judge has made a remark about it. It's not apparent unless you show us that she's carried that forward into her decision.
Yes, the submission that I make is that when it comes to the insurmountable obstacles test, the age is simply irrelevant. That may be of some relevance to the question of relationship itself, but it's common ground that the relationship is genuine and subsisting.
So, do we know whether or not the judge was referred to Lal? Because it's
2019. No, I think Lal was not even available
yes.
when
Well,
it
so
was decided.
Lal is November the 8th, 2019, and this decision is
October 2019.
right. So in fact the hearing in Lal had taken place "12 days before the
Yes.
first tier tribunal decision, and the judgments had not been given.
No, but of course, what Lal said was the law when the tribunal decided this case. So the
Yes.
fact that it was handed down afterwards that does not mean that my complaint isn't well founded. If it's not well founded, it's not well founded on its merits.
Yes, I know, but I mean, Lal suggests a methodology,
Yes.
and the first tier judge would have been prescient if she had identified that methodology. So what's the substantive point is that you say that she failed to engage with the wife's vulnerability.
Yes. That is the point. Yes.
Yes.
That is the point, and you have. I mean, I have made five particular points, and I've made.
Is this in your skeleton argument?
And these points are in my skeleton.
I think you've been tracking them, haven't you, in what you've just been saying?
Sorry.
You've been tracking those in the points that you've just been making.
Yes, I've made my point. Yes, so just to answer the point that that Milady made as to whether the sort of first point that I made was made in the grounds. I think the best that I can do is to show you what is stated at paragraphs 39 to 42 of those grounds. This is page 254 of the bundle. I'm not, but I do submit that if the submissions that I've made are not good, the court rejects them. But if they are good, then
essentially what's being said as I read the first tier judgment is that your client and his wife simply didn't make the case.
yes, but the submission, of course, is you have my submissions, and as I said, no pleadings point is taken, at least in writing or in the respondent's notice. Permission was granted on all these grounds. Given that my lords and milady know about about the wife's background and what is at stake here, I do ask you to allow the appeal. If any of the submissions that I've made are good, if they are not good, my lords and my lady will dismiss the appeal. So unless I can assist you any further, for these reasons, I respectfully invite the court to set aside the decisions.
I've got a timing question.
Yes.
We've just been looking at the application of paragraph EX1 and the insurmountable test, which is very significant difficulties which would be faced by the applicant or their partner in continuing family life together outside the UK, which couldn't be overcome, etc. What's the timescale inherent in that test in a case in which you say your client would be entitled or would certainly be able to come back if he were outside the UK?
Yes.
I mean, because the answer may be very different, might it not? Where somebody was outside the UK, was required to be outside the UK for a short period of time or a long period of time.
No, what paragraph EX1 contemplates is permanent relocation. I mean, of course, if there are insurmountable obstacles to relocation, the appellant qualifies under the rules, and Chikwamba point does not arise. In one way, this is perhaps the point that arises before the Chikwamba point, because Chikwamba only arises where the rules are not met. But I address the court on the common issues first. But EX1 contemplates permanent relocation, and that is how the tribunals assessed this appeal. They said that the wife can permanently relocate to Bangladesh, and that is what I seek to challenge. If I'm wrong about it, the Chikwamba point then comes in.
Yep.
That, well, even if the requirements of the rules are not met, this is a case where what's going to happen in reality is that the appellant will apply for entry clearance, will come back, and that is a point that ought to be taken in his favour.
Mr. Malik, thank you very much indeed.
Very grateful.
Yes, Mr. Hanson.
May it please your lords, my lady. Can I check, is the lighting improved now?
I think it's good enough. Assuming you go over lunch, we're not going to deter you from making further efforts, but let's move on now at least.
All right, thank you very much. Can I follow my learned friend's order, dealing with the common issue first, and then dealing with the individual circumstances of each appeal, and the additional ground that arises in Mr. Allen's case? My lords, can I take you back to Chikwamba it begins at page 76. Can I invite your attention to certain passages that your lordships and my lady weren't taken to earlier, beginning at page 86, paragraph 37. If the court has that, the overarching submission in relation to Chikwamba is that the facts of that particular case are crucial to the ultimate decision. But the particular feature of that case that warrants attention is apparent from paras 37 and 38, where the decision in that case was mandated by the underlying decision by the Secretary of State, was effectively mandated by what might be called the rigid or over-rigid application of the policy set out in the relevant policy instruction at the time that required persons in the appellant's position to return home and make an entry clearance application from abroad. And you'll see the policy instructions set out at para 37. And at para 38, Lord Brown makes the point, it would appear that this was the policy applied in the claimant's case. And in my submission, this feature of the decision, and indeed the subsequent discussion in the case law, is vital in understanding the real ratio of Chikwamba. What was Kafkaesque about the decision in Chikwamba was the rigid application of a policy requiring an entry clearance application from abroad, regardless of the underlying facts. And the particular facts that justified the conclusion of the court in that case that it would be disproportionate to require an entry clearance application from abroad were stark and, one might say, obvious. First and foremost, the claimant's spouse couldn't return to Zimbabwe because he was a refugee here and had been granted asylum, and so would be at risk if returned. Secondly, the claimant and her spouse had a very young child. Thirdly, conditions in Zimbabwe were described as harsh and unpalatable. Fourthly, the enforced return of failed asylum seekers, of which the claimant was one, had been suspended for 2 years since the parties had married. And finally, there was no doubt on the facts of that case that ultimately the family would be allowed to live together in the UK. But I say Lord Brown clearly accepts in his speech that the maintenance and enforcement of immigration control is a legitimate aim, and the deterrent objective of requiring an entry clearance application from abroad is unobjectionable. But it was the particular facts of that case that dictated the result. And I invite your lordships to look again at the statement of principle in that context, but also on its own terms. It's at paragraph 44, page 88, at letter E. Rather, it seems to me that only comparatively rarely, certainly in family cases involving children, should an Article 8 appeal be dismissed on the basis that it would be proportionate and more appropriate for the appellant to apply for leave from abroad. Well, that's not either of these cases. Neither of these cases have been dismissed on that basis. They've been dismissed on the basis of a multifactorial balancing exercise involving the consideration of a wide number of relevant factors, including the issue of precariousness centrally, including the issue of the appellant's immigration history more generally. One came to this country as a working holiday maker on terms that they would return at the end of their visa. The other came to this country as a visitor on the same terms. And I say that neither of these applications has been decided on that narrow procedural ground that attracted the attention and criticism of the House of Lords in Chikwamba. I also endorse the point my Lord Justice Snowden made, that whilst it's not a trump card against an appellant in this position, it is relevant in both these appeals that there are no affected children involved. And whilst before we leave Chikwamba, can I just draw one further point to your Lordship's attention? At paragraph 42, between the letters G and H, Lord Brown said in an Article 8 family case, the prospective length and degree of family disruption involved in going abroad will always be highly relevant. And it's in that context, for example, that the the findings about insurmountable obstacles or the lack of them is relevant. So I say that the actual principle in Chikwamba is clear enough, but neither of the present cases has been decided on that narrow, mechanistic or rigid basis.
Sorry, Mr. Hanson, just between G and H, so I'm not sure I'm following the point you're making. Between G and H, after making the point about family disruption, there is a sentence talking about good reason to apply the policy if the entry clearance officer abroad is better placed than the authorities here to investigate the claim.
Yes,
etc.
I'm not relying on that point here.
What is your actual position on the likelihood or certainty of Mr. Alam being returned to the UK, or returning to the UK if an application is made from abroad? Because your skeleton argument is somewhat equivocal on it and talks about current circumstances but without giving any further information.
Well, can I say this? Can I make 2 points? Firstly, in my respectful submission, the test in considering the merits of any entry clearance application is certainty. It's not, in my respectful submission, more likely than not or some other test. It's certainty, and that appears clearly from Lord Reed's speech in Agyarko. Secondly, the reason for what might look like equivocation in what I say in the skeleton arises out of what the senior president said in PZ, and it might be sensible if I just take your lordships and my lady to that now. It's at page 320. You've looked at it before, but I think not on this point. And at page 329, para 39, right at the end of that paragraph, where the senior president is considering Chikwamba, EB, Kosovo, and so on, he says in the last sentence, the facts of the case are not analogous to the circumstances in Chikwamba because the outcome of the subsequent entry clearance application by TZ is not certain. That's the first point. But then he goes on to say, both the nature and extent of his relationship with AS and his financial situation at that time will be relevant. And given that the consideration of Chikwamba is premised on the outcome of a putative entry clearance application to be made in the future, one can see why the senior president used that language. Now, no doubt my learned friend would make the point that what matters for the purposes of this assessment is the state of the evidence before the FTT or the upper tribunal if they're remaking. But I simply make the point that there is some support in the case law for the proposition that what actually matters is the nature and extent of the relationship and their financial situation at the time of the entry clearance application.
Well, sorry, can you just break that down? The relationship, as I understand it, has been entirely formed in the UK.
Yes.
So how is somebody abroad going to be better placed to assess the nature and the extent of the relationship?
My lord, I'm not making the point that the entry clearance officer would be in a better position to assess that. I'm simply making the point, a point about timing.
Well,
at what point is it appropriate to consider, for a better example would be, at what point is it appropriate to consider whether the financial eligibility rules are or will be satisfied?
Well, is that on the footing that the applicant's spouse has had to give up her job to move abroad and therefore won't have any means of support?
No, I think it's on the simple footing that circumstances change, and if the relevant time for assessing.
Well, they will do if by definition they will do if a person with a job in this country has to give it up to go abroad.
But even if they don't go abroad and they remain here, I think it's a simple point that one can't necessarily assume that their sponsor's financial circumstances will remain the same. But this is not the gravamen of my submission. The thrust of my submission is that neither of these applications were refused on the narrow application of the what used to be a policy instruction requiring applicants in this position to apply for entry clearance from abroad. They were both decided on the basis of a full proportionality assessment. And I say, in those circumstances, the Chikwamba principle's not engaged as a matter of principle.
So is that the point the upper tribunal's getting at?
Sorry, I didn't hear
I'm
that.
sorry, it's my fault. Is that the point that the upper tribunal was getting at when considering the reasoning of the first tier tribunal in, I think it was SA? Well, perhaps
in my respectful submission, that's the basis of the decision making in both cases.
right.
Can I move on to another case that,
Sure.
in my submission, makes good that overarching submission? My learned friend, for understandable reasons, focused on case law in this court and the Supreme Court that postdates Part 5A of the 2002 Act, and I understand that, and I make no criticism. But in understanding the true scope of the Chikwamba principle, in my submission, it's legitimate to consider case law that predates July 2014, and in particular case law in this court, where the court has embarked upon a detailed consideration of the principle in the light of Chikwamba.
Is it right to call it a principle? I mean, isn't Chikwamba simply saying that in a case where people would be required to leave only to return, that is capable of being a powerful factor in considering whether it's proportionate to require them to leave?
Yes, I'm happy with.
I mean, isn't it?
That,
I mean, isn't it really identifying something that may, in certain cases, be a weighty factor?
Yes.
I slightly bright, unless you're probably going to take us to many cases in which it's been described as the Chikwamba principle. But I mean, it sounds a mighty thing, but actually, isn't it only a piece of fairly obvious reasoning that is likely to appear in some cases, maybe, but not in others?
Yes.
All right, but anyhow, we know what you mean by the Chikwamba principle, but
yes. Can I invite the court's attention to page 102, the decision of this court in Hyatt?
yes.
Can I invite the court's attention first to paragraph 1, just to set the scene? There were two appeals heard together. Each raises, says Lord Justice Elias, matters, issues concerning the proper scope and application of the decision of the House of Lords in Chikwamba. So that's what the court was dealing with. Then at paragraphs 2 to 18, they set out the facts and decision in Chikwamba. At paragraphs 19 to 29, you can see under the subheading subsequent Court of Appeal decisions, they embark upon a detailed consideration of, as they describe them, other subsequent Court of Appeal decisions. And then at Para 30, page 111, they set out or summarise the principles as they understand them. And I rely on that statement of principle, beginning centrally with little a, the point I made at the outset.
Yes.
I rely on that statement of principle, and I invite the court's attention, in addition, please, to the discussion beginning at paragraph 47 at page 116. And in particular, paragraphs 49 to 51, where the court make the point, beginning if one looks at para 49, on a fair reading of those paragraphs, I do not agree the immigration judge has dismissed the Article 8 application simply on the formalistic basis that the application should be renewed from Pakistan because rules should be obeyed. And then the court goes on to say that, in fact, what the tribunal judge has done is conduct a balanced consideration of the relevant factors, including the likelihood and duration of any possible period of separation. And finally, in this decision, can I refer the court to paragraphs 80 to 81, which in my submission makes clear the true scope and application of what is there described as the Chikwamba principle. I draw the court's attention in particular to the last two sentences of paragraph 81, beginning, the judge carried out a full proportionality assessment considering the merits of the claim. Chikwamba has no application in those circumstances. And my lords, my lady, following Hayat, in my respectful submission, first instance judges with vast experience in this field treated Chikwamba, as interpreted by Hayat, as only being engaged where the Secretary of State refused the application on the procedural ground that the policy required the appellant to have made the application from abroad. And one example of that is Thakral at page 314. I accept it's a first instance decision, but it's a decision of Mr. Justice Nichol, made after the decision in Hyatt, and one sees in italics the statement of principle that he distills from Hyatt. So, my lords, my lady, just taking stock at this point, before interweaving the effect of sections 117A and 117B of the 2002 Act, I submit both these applications and indeed the subsequent appeals have been determined on the basis of full proportionality assessments. Neither was decided on the narrow procedural ground that the appellant should apply for entry clearance from abroad. They were both decided on their substantive merits. And we haven't, I think, looked at the underlying decisions of the Secretary of State, and I don't think we need to dwell on them for this purpose, but a brief reference to them makes that point abundantly clear. The underlying decisions, my lords, my lady, in Mr. Allen's case begin at 168. In Mr. Rahman's case, beginning at 175. And as is clear from the face of the decisions and the factors that are referred to, neither is decided on any narrow procedural basis. Both involve substantive merits consideration. And in my respectful submission, we're not in Chikwamba territory, and nothing in the statutory framework alters that conclusion or impacts upon it. And one sees, if one looks, for example, at Mr. Allen's decision letter at page 168, one sees his immigration history set out, the fact that he's remained in the UK illegally following the expiry of his leave. One sees a consideration of insurmountable obstacles. One sees at page 172 the fact that weight is being placed on the fact that he has entered into his relationship whilst his status was precarious. In fact, it was unlawful, but it was clearly a fortiori precarious. And so I say that's the basis upon which this court should look at the decision making. I'm conscious of the time.
Well, in that case, could I ask you a question?
Yes.
Amidst all the authorities, which we've been taken to some but not all, are there any examples of a decision having been overturned on the basis of Chikwamba? And if so, because I'll clearly ask Mr. Malik the same question if he doesn't get there first, which authorities are they, so that we can see cases in which Chikwamba has been interpreted consistently with Hyatt as being a purely procedural matter. Now, you may want to think about that over lunch if you like, so you can answer compendiously. But I'd be interested to know whether there are some examples of the same argument that we're considering being pursued to a successful conclusion. Would that be a convenient moment then to leave matters?
I think it would be in the light of that, my lord.
All right. Well then, we'll start again at 2 o'clock. How long do you expect your remaining submissions to take?
Another hour, I would say.
Well, we're comfortably within our timetable then. Thank you very much. All right, 2 o'clock.
Thank you.